Hi there. Let me get started. We still have some people coming in, but I think my introduction will take a few minutes to allow folks to be seated. As many of you know, my name is Phil Weiser. I'm the dean here. Those of you I haven't met, we have a reception afterwards. Our principal purpose is to enable our students to meet people from the community here. How many students are here? All right, that's an awesome turnout. That is wonderfully reflective of how Kristen Carpenter is beloved in many quarters. How many faculty are here? Whoa, is right. And how many alums are here, community members? All right, so the community members are outnumbered, but we will look forward to visiting with you as we come together for a very special occasion. Every year, we have the Austin Scott Lecture. We list many of the distinguished lecturers, and we have many of them here, including colleagues who have retired but are part of our community, so Al Canner, Mimi Wesson, others. We appreciate all of you joining us for this yearly gathering that honors Austin Scott, who was a beloved teacher, just like Kristen, and a prolific and celebrated scholar, also just like Kristen. The opportunity to engage with our work is something that we get to do often in smaller works in progress, in colloquium. It is also something we get to do in a public setting at rare occasions where faculty, staff, alums, and staff, I guess I didn't mention staff members. How many staff members are here? Okay, thank you guys for joining. It's something that we need to really sit back, celebrate, enjoy. Kristen's work is a unique blend of theoretical, critical, engaged, practical work. I can't do it justice describing it, but I will tell you, when you talk to people in her field of Indian law, her and Sarah Krakoff, another one of our colleagues, are always at the top of the list. Now that is a fitting tribute because Charles Wilkinson and David Getches literally put that field on the map. Rick Collins, who's also worked some in that field and argued a whole bunch of Supreme Court cases, is another member of that community. And we've had one of the only American Indian law clinics, now led ably by Carla Fredericks. So this community of American Indian law is something that we here are very proud of. It's one of our core pillars of Colorado law. The Native American Rights Fund is here in Boulder because David Getches, when he was the head, brought it here. And that relationship remains powerful and strong. So this is a powerful tradition. You are an incredibly gifted and valued part of this community, both the American Indian law community, the Colorado law community. I'd like to give Kristen the floor.
Thanks, Phil, for the very kind introduction. And to all of you for being here. I went on and on for a paragraph and a half in the program, thanking all of my friends and colleagues and supporters. And really, I could have thanked almost everybody in the room individually. So truly know that I appreciate you for being here and your support of my career and work. The title of my talk is Indigenous Peoples and their Jurisgenerative Moment in Human Rights. And this is a topic that I approach with sincere humility. People around the globe, and many people in this room, have been working in the movement for much longer than I have. And these issues are complex, and they affect real people. I look forward to your comments and ongoing dialogue about the points that I bring up here. This presentation is based on research and writing that I have done for a long time with my co-author, Angela Riley, and I'd like to acknowledge her, along with my spouse, Thatcher Wine, for his never-ending support, and the many others that really have brought me to this moment. So what makes this such a remarkable moment and a jurisgenerative one? In 2007, after advocacy by Indigenous peoples for decades, the UN General Assembly voted by 143-4 to adopt the Declaration on the Rights of Indigenous Peoples, an event that many of us thought we would never see in our lifetimes. After so many struggles to have their rights recognized at all, Indigenous peoples have now changed their focus to implementation of those rights. to making real the concepts of self-determination, freedom from violence, religious liberty, economic well-being, and so many others. As Walter Echohawk has said, the adoption of the Declaration is a landmark event that promises to shape humanity in the post-colonial age. And the question facing many community members, advocates, and scholars is how to deliver on that promise, to engage in reform that fundamentally improves the well-being of Indigenous peoples in relationship with others around the world. As I will describe later, this challenge is especially poignant in light of critiques of the human rights framework, not least of which is its potential to be a tool of Western liberalism or even imperial power structures in ways that are fundamentally at odds with Indigenous cultures and an anti-subordination agenda. What my co-author and I argue in the paper is that there are two underappreciated dynamics that may help to inform these critiques. First, borrowing terminology from the legal theorist Robert Cover, we note that Indigenous peoples are and have always been law-creating or jurisgenerative communities with their own legal traditions, deep, extant, and abiding. They're not sitting idly by, waiting for the received wisdom of diplomats from Geneva, but rather acting as agents in their own destinies. Indigenous peoples in many examples, including the Declaration's drafting itself, effectively assert their own norms and values in a multi-state process of international, domestic, and tribal advocacy. Second, this is a period marked by new developments in decolonization theory and practice, in which Indigenous peoples are not only using the language and institutions of human rights to take on states for oppressive actions, such as the denial of land rights or removal of children from their families, but also, and just as importantly, engaging with human rights as a tool for internal decolonization, the recovery of tribal values, and reform of Indigenous governance. In these ways, we argue the world is witnessing, and Indigenous peoples are leaders in, a jurisgenerative moment, a moment when human rights have the ability to become more capacious, embracing norms of individual equality and collective self-determination, and multiple means of implementation to affect the ways that individuals and peoples around the globe live and want to live. It's not happening overnight, but it is happening, and that's the story I'll try to tell here. So I'll divide the remainder of my presentation into 4 parts. Phil gave me 45 minutes. I'll try not to take quite that long and save at least 10 minutes at the end for Q&A. But I'll first provide some background on the situation of Indigenous peoples and their history in this movement. Second, describe more fully some of the critiques of the international human rights framework in this context. Third, expand on the theoretical insights from Cover and the decolonization work of a number of scholars. And fourth, and this is sort of the heart of the project, share several case studies revealing jurisgenerative moments that may signal best practices for the implementation of the Declaration and other rights that we're also concerned with right now. But first, let's start with some facts, figures, and definitions. The NGO Cultural Survival estimates that there are approximately 370 million Indigenous peoples around the world, belonging to 5,000 different groups in 90 countries worldwide. They speak over 4,000 languages, followed varied lifestyles, cultural and socioeconomic practices, and draw from ancient traditions, land tenure, internal self-governance, and diplomatic relations with neighboring peoples, all of which continue today. Historically, however, Indigenous peoples have been often dispossessed of their property, subjected to conflict over valuable resources, and indeed Indigenous peoples today are among the most disadvantaged in the world, having experienced in some cases over 500 years of conquest and colonization by European and other powers, sometimes amounting to genocide. Indigenous peoples today constitute only 5% of the world's population, yet account for 15% of the world's poor. In many countries, including our own, Indigenous peoples experience disproportionately high rates of suicide, disease, unemployment, interracial violence, and other indicia of human suffering. Yet Indigenous peoples are also resilient, diverse, and above all, intent on their survival. Featured from top left, and these are just some snapshots, some friends that some of you may know, are members of Osage and Cherokee, Sami and Aboriginal, Potawatomi, an Indigenous woman in the middle of unknown tribal origin living on the streets of Bogota, Twa, Western Sawari, San, Mosquito, and Ho-Chunk people, in nations including the US, Norway, Australia, Colombia, the Eastern Democratic Republic of Congo, Western Sahara, Botswana, Nicaragua, and back to the US again. Each of these peoples comes from Indigenous communities with distinctive cultures and experiences, histories and struggles. But yet, as the contemporary movement shows, Indigenous peoples across the world also have many things in common. Spread from the Arctic to the South Pacific, they're descendants, according to one definition, of those who inhabited a country or geographical region at the time when people of a different cultural or ethnic group arrived. Through conquest, occupation, settlement, and so on, the new arrivals became dominant and the Indigenous peoples became oppressed. To quote another definition, this one from the former UN Special Rapporteur on the Rights of Indigenous Peoples, Jim Anaya, Indigenous peoples are indigenous because their ancestral roots are embedded in the lands in which they live or would like to live, and they are peoples to the extent they comprise distinct communities with a continuity of existence and identity that links them to the communities, tribes, or nations of their ancestral past. These are the people who are in one way or another involved in the structures and processes of human rights advocacy as it pertains to Indigenous peoples today. While the human rights movement may be a modern invention, Indigenous peoples' involvement in what we today call international law and diplomacy stretches back at least to the 15th century and encounters with Europeans at that time. And going back all the way to that time, there's been vigorous debate about whether international law operates as a sword or a shield in the lives of Indigenous peoples. 15th and 16th century Spanish theologians, for example, offered both a natural law defense of the humanity of Indigenous peoples against the efforts of conquistadors who sought to kill and enslave them, but they also proffered the concept of a just war in instances where Indigenous peoples rejected the authority of the Pope. If Indigenous peoples did not accept Catholicism or Spanish rule, whether they understood either, then their lands could be justifiably taken, pillaged, and destroyed. Notwithstanding these origins and the Spanish experience, representatives of other European monarchs and later states found that as a practical matter, it was often expedient to negotiate treaties with Indigenous peoples regarding trade, property, and governance rights. And here you see some treaties on the bottom, commemorating mutual promises of political alliance, land cession, governance, and trade. For the most part, these instruments were amalgamations of international, state, and Indigenous law, legal customs, and practices, all mutual agreements based on the circumstances in which Indigenous and European nations found themselves. Increasingly, however, as states became ascendant, they asserted their domination over Indigenous peoples within their borders, and also, as Phil Fricke said, began to domesticate the law regarding Indigenous peoples. And so, for example, in the United States, when Chief Justice Marshall evaluated the legal status of Indian tribes, he embraced the international doctrine of discovery to diminish tribal property rights vis-a-vis the United States, and held that with respect to self-governance, tribes were now domestic, dependent nations, with inherent, albeit diminished, political rights that did not include, for example, the right to sue in the federal courts. Marshall tried to strike a balance between national and tribal rights, and the Marshall Trilogy has had abiding force in establishing the reserved rights of tribes in the U.S. Yet his decisions were also followed by numerous forced marches, dispossessions, relocations, and massacres, and the diminishing health and well-being and populations of U.S. tribes, which reached their nadir in 1900. In modern times, though, we have seen the emergence of an important phenomenon, and that is Indigenous peoples' demand to be treated as subjects rather than objects of international law. When, for example, Canada began to interfere in the internal selection of chiefs in the 1920s, the Haudenosaunee people sent their leader, Descahe, to the League of Nations to make the case for self-government based on a treaty with England. Canada objected to his presence, and the League refused to receive him, as it did with a Maori leader several years later. But Indigenous peoples by this time had begun to avail themselves of international tribunals to press for their rights as entities. Once formed, the United Nations in the 1950s and 60s began to study the situation of Indigenous peoples, albeit without their meaningful participation. For example, earlier treaties of the International Labor Organization called for attention to Native workers' rights in colonized countries, but did so in a way that suggested that Native cultures and economies would soon fall sway to the powers of industrialization. By the 1960s and 70s, however, a larger group of educated Indigenous leaders began to form coalitions, travel more broadly, and speak back to the institutions of international law. At the left, you see Haudenosaunee leaders in the 1970s attending meetings of the UN, pressing for their rights to be considered under treaties. Why the desire to go to international forums? First, it appears that the courts of the conqueror often face certain limitations when it comes to adjudicating indigenous legal matters. One of those limitations is that the Supreme Court decides almost every Indian case it hears against the tribes. Our late Dean David Getches demonstrated that the loss rate during the Rehnquist court was over 80%, and under the Roberts court, it's close to 90%. As a result, in the United States to this very day, tribal Aboriginal property is not property under the Fifth Amendment. The court has held 3 times since 1988 that the First Amendment does not protect the religious freedom of American Indians. And it continues in case after case, one before the Supreme Court right now, to diminish tribal court jurisdiction based on perceptions that invoke stereotypes about Indian inferiority and difference. Even statutes enacted under the current policy of self-determination, such as the Indian Land Reorganization Act's provisions for the recovery of land, or the Indian Child Welfare Act's protections for Indian families, have been construed so narrowly as to make their remedial effect almost null. When they reach the ends of advocacy in the US, that's when Indigenous clients ask their lawyers for further options, and they begin to look internationally. Moreover, as international law has embraced human rights principles in the post-war era, including the protection of minorities from state oppression and recognizing broader rights of self-determination by former colonies, it appears there may be some room to architect space for Indigenous rights in a way that domestic regimes do not. For all of these and probably other reasons, asserting a voice in international legal forums has been a key objective of the Indigenous peoples movement. As James Henderson and others have described, Indigenous peoples have expended a tremendous amount of time and energy to bring their voices to the UN. Throughout the 1980s and 90s, they participated in meetings of the UN Working Group on Indigenous Peoples' Rights. And today, as a result of this advocacy and growing awareness of the common claims of Indigenous peoples around the world, there are a number of mechanisms specifically devoted to Indigenous rights at the UN, some of them featured here on the slide. And Indigenous peoples also have a presence at other mechanisms where their rights are on the agenda in a way that they haven't been before. I apologize in advance for this slide, which has too much text to really digest, but it's the only one, hopefully, like this. Not coincidentally, right, with the rise of Indigenous peoples' participation in international legal forums, the world order, in turn, this is the world order here, increasingly recognizes Indigenous peoples as individuals and peoples with the right to have rights. This is true first as a matter of international human rights instruments that apply across the board. And so on my right, your left, you see the International Covenant on the Elimination of All Forms of Racial Discrimination. Indigenous peoples have brought claims under this convention, which has 168 state parties, to argue that when, for example, the United States fails to recognize the Aboriginal title of tribes here, that's racial discrimination. Similarly, under the International Covenant on Civil and Political Rights, which is a widely ratified treaty, Indigenous peoples have made arguments that are broadly available. Article 27's protection for minority cultures is a provision that many Indigenous peoples, as in the Lubicon Band case, have tried to use to argue in favor of claims that they have with respect to the destruction of their culture. On your right, however, are 2 instruments that more particularly pertain to the situation of Indigenous peoples. So the ILO's 3rd treaty on Indigenous peoples issues, 169, talks specifically about Indigenous populations and tribal peoples, and of course the UN Declaration, as we've already mentioned, and I'll alternate between Declaration and the UNDRIP, which is its acronym, enumerates 46 articles specifically protecting different rights of Indigenous peoples to, as I said earlier, self-determination, equality, non-discrimination, and so on. Each of these instruments, except for perhaps the UNDRIP, has with it an enforcement mechanism, a system of reporting, complaints, and whether or not the treaty is going to be binding on a particular state depends on whether it has ratified it, of course, whether it has acceded to the tribunal that adjudicates claims under it, and we can't probably get into too much more detail at this particular time here, but the point is there is a growing body of law, both generalized and specific, in international human rights law that gives Indigenous peoples a platform on which to bring their claims. And yet there are criticisms of this movement, even with all of its development. Critiques coming from a really diverse group of writers, including Maka Matua, Martha Minow, Karen Engel, Dwayne Champagne. I think I saw in the audience our very own Joe Bryan, Glenn Morris. Others have enumerated some of the potential problems and issues associated with advocacy under the body of human rights law. In our paper, we divide that skepticism into two categories. One is skepticism about human rights, and one is skepticism about arguments around culture. And I'll try to go through these quickly, but they are important. First, running through discussions on the Declaration is a concern that human rights law represents, again, the imposition of a foreign legal culture on Indigenous peoples. That it, again, with all of its lofty notions, is still a device of assimilationist power being asserted over the lives of Indigenous peoples. The fact that Indigenous peoples are not recognized to participate as such at the UN, and in fact have to come into the UN under the credentials of a non-governmental organization, try telling the Navajo Nation or the Cherokee Nation that it's not a government, and that the UN is therefore still a good place to go. And you can see how this assimilationist overtone is one that gives people a lot of concern. Second, there's a critique that in its reliance on rights, the human rights regime threatens to fix and rigidify relationships, creating haves and have-nots among Indigenous peoples, and even engendering conflict among them. Here, struggles among Indigenous peoples in Nicaragua after successful land tenure cases possibly illustrates this point. And finally, there's a critique that international law, including human rights law, is difficult to enforce and unlikely to remedy in any tangible way the struggle of Indigenous peoples who live under oppressive state regimes. For this reason, it may be unappealing to Indigenous leaders to expend precious time and resources going to Geneva and going to New York and everywhere else around the world to make those claims. One of the pictures up here, the one that is on your left of Mount Tenebo, shows a Western Shoshone sacred site being subject to cyanide leach gold mining a number of years after the Committee on the Elimination of Racial Discrimination told the United States to cease and desist those efforts until it could fairly adjudicate the property rights of Western Shoshone people. On the culture side, some have argued that by appealing to concepts of tradition, for example, the Declaration panders to notions of Indigenous people stuck in the past. Described by scholars as the problems of cultural cohesion or strategic essentialism, some terms of the Declaration may be seen to limit the adaptability and autonomy of Indigenous peoples. What if an Indigenous group, for example, does not want to maintain a subsistence lifestyle, but rather participate in extractive industries? Do provisions on the spiritual relationship with land make those choices difficult? A second strand from the culture critique considers conflicts within groups that purport cultural cohesion, noting that by empowering groups to govern by customary law, the Declaration could reify internal patterns of subordination to the exclusion of individual liberties that are supposed to be at the heart of human rights themselves. Indigenous women who have struggled for internal voting rights in communities ranging from Mexico to the US can attest to some of those struggles. In these ways, all of the critiques are apt, of course, and they offer important cautions. But at this point in the Indigenous peoples movement, it is also possible that the critiques are undeveloped and not taking into account some of the trends that we see occurring in Indian country. These are trends that might be important as we consider best practices in the implementation of human rights in the lives of Indigenous peoples. To begin and to capture and account for these developments, we turn to the work of legal scholar Robert Cover, who in his famous work, Nomos, a Narrative, identified what he called Padaic communities, whether Amish, Mennonite, or Orthodox Jews, whose commitments to a sacred narrative or commitment are so deep that they become law-creating through the acts of daily life in ways that challenge and inform the societies around them. For Indian people, with their often intertwined religions, cultures, and laws, this description seems apt, and it may also be reflected in federal law to the extent that it recognizes tribal sovereignty and the right of reservation Indians to make their own laws and be governed by them. Indian tribes are and have always been jurisgenerative communities, but their history and current reality are infused with a particular experience as well. They have, as a matter of religion, culture, economy, and politics, been colonized by invading governments who have sought to replace indigenous lifeways and processes with what Patrick Wolf says is an ongoing structure of domination. Thus, the hope of liberation for indigenous peoples rests on a process of decolonization, even if that practice and process will never be fully complete. Thus, tribes will continue to argue and must continue to argue that their religions are religions under the First Amendment, that their lands are property under the Fifth. Principles of equality and non-discrimination require nothing less. As Jim Anaya and Rob Williams have argued, universal precepts of human rights law applied in the indigenous context should recognize those rights. To further address challenges in contemporary times, however, indigenous peoples must do more than seek redress against states. They must look both outward and inward. As scholars including Rob Porter and Navajo Nation Justice Ray Austin have argued, to truly empower the freedom and potential of their members, indigenous peoples are acknowledging and disentangling the many ways in which they've been forced or encouraged to adopt some of the practices of the colonizer. This argument has been made, especially in the case of tribes where the federal government in the U.S. has had a strong hand in drafting their constitutions, or the tribal Supreme Court has sided to the laws of surrounding states instead of their own. These include cases where instead of traditional kinship norms, they now apply citizenship rules that exclude vulnerable populations. And as they revitalize their cultures, many tribes are simultaneously engaged in governance reform, a process that involves both uncovering tribal norms and updating tribal laws and institutions to contemporary circumstances. If this process occurs, it must occur simultaneously in a mutually informed way through tribal, state, and international forums. In some ways, right, this process and this observation about the multiple site nature of decolonization comes from international law itself. Treaties, as many of you know, are non-self-executing and require for their implementation states, or tribes for that matter, to adopt legislation affecting them. Of course, the same would be true, if not more true, of the Declaration, which has even less force as a matter of international law. But once passed, national legislation may bind polities to international rules and tribunals, or to programs that comply with international standards. And so international legal change is necessarily a multiple site project, as Judith Resnick has observed. What is so transformative, we think, in this context is that indigenous norms and values are clearly ascendant in these processes. And I'll offer just a few tiny snapshots of examples and then 2 case studies and then wrap it up. Oh wait, I don't want to get to my main examples. So the snapshots, so these are meant to be examples where we see indigenous, national, and international legal forums all working together through a process of decolonization and hopefully jurisgeneration. So consider a few examples. The Belize Supreme Court in 2007 became the first national Supreme Court to cite the Declaration in an opinion. My students are smiling because we talked about this case just today in class. This was a case that remarkably recognized indigenous customary land tenure as the source of property law cognizable under the state constitution of Belize, and referenced back to the Declaration's recognition of indigenous customary law as a cognizable property right internationally as well. In the legislative arena, Peru has recently adopted the requirement from the Declaration of free, prior, and informed consent, meaning that people there should have the opportunity to provide consent before oil concessions are granted to their lands, a departure from past practice for sure. In Mexico, where there's been constitutional protection for traditional customary law as it governs inside communities, again consistent with the Declaration, Oaxacan women have cited attendant norms of equality to successfully press for their voting rights in at least 60% of indigenous villages, according to one study. In all of these places, indigenous peoples are standing ready to make human rights commitments real, and often in ways that reflect the particular circumstances of the country. And so in the United States, for example, we see all sorts of formal lawmaking opportunities. One agency, the Advisory Council on Historic Preservation, has already adopted the Declaration as a matter of law. Advocates are already citing the Declaration in briefs. Surely at least one federal court will come back and cite the Declaration in an opinion. In other places, though, and Peru is one of them, we see Indigenous peoples resisting under the principle of a lack of free, prior, and informed consent to allow companies to come into their communities and engage in oil development when they haven't had the opportunity to meaningfully consent. These examples are meant to be from places around the world and pretty short versions of them. To make them a little bit more real, I'll share two studies that we looked at in the United States. One that concerns a major advancement in federal Indian law with respect to addressing violence against women, and the other that concerns a tribe's creation of its own human rights tribunal. So I'll start with the situation of violence against women. As these statistics show, Indian women in the U.S. experience violent crimes at rates that are remarkable and devastating. For many years now, American Indian women have been involved in advocacy to address this epidemic. One aspect of the story, absolutely, is advocacy occurring simultaneously and relatedly in tribal, domestic, and international forums. There are versions of this story occurring in tribes all across the country, but the one I wish to tell here concerns the Eastern Band of Cherokee Indians. Some years ago, women in the Eastern Band formed a nonprofit called Clan Star Inc. to address violence against women in their community. It was led by an elected tribal council member named Terry Henry, and together they worked on tribal and national legislation to address the problem. In 2011, Eastern Cherokee women expanded their efforts, and they, along with the Indian Law Resource Center, looked internationally and brought the UN Special Rapporteur on Violence Against Women, Rashida Manjoo, to the United States. She spent some time at Eastern Cherokee. Her purpose was to highlight the situation of Indigenous women in the United States vis-a-vis the situation of Indigenous women around the world. And in that process, she shed light on a story that has everything to do with tribal values, colonization, and recovery. The Special Rapporteur's visit to the Eastern Band began with a discussion of Cherokee traditional law and culture, which had historically served to protect women from violence. We often hear in Indian country that violence is not traditional, but the Cherokee example puts some context on that statement. As Theodore Perdue and others have written, Cherokee culture was matrilineal, matrilocal. Women owned their homes and the fields, and women and children lived in extended families with parents and siblings, rather than in isolation with spouses. The Cherokee cosmology included powerful women figures, an ideal of harmony and balance, and models for the peaceful resolution of disputes between spouses. According to Renard Strickland, social order was maintained by a clan system in which relatives had an obligation to avenge crimes, including rape or murder, when committed against women. This is not to say that such crimes didn't occur, but that there were extensive social, cultural, and legal means of dealing with them. And just to give you a little bit of context here, the painting by Dorothy Sullivan of the 7 Cherokee women represent each of the 7 clans, and women served at the heads of their clans, and you see a number of the clan characteristics in the clothing and the masks and the attributes that they're holding. The woman on your left is a woman in front of her own cabin that she owned with other women in her family. But much of this system began to change as Europeans moved in, established trading posts, and gobbled up Cherokee lands. So each of the numbered sections here in the famous Charles Royce map shows a cession of Cherokee lands to European, colonial, or U.S. governments. Christian missionaries moved in also, encouraging Cherokees to first give up their traditional religions, their beliefs and ceremonies, and adopt Christianity. And just as impactfully encouraged Cherokees to abandon their socioeconomic practices and adopt those of whites. And so Cherokee women were not supposed to be in the fields planting and harvesting their corn. They were supposed to stay home and weave and sew. Men were supposed to stop hunting in favor of farming. And families were encouraged to live in nuclear families instead of in clan relationships. In all of these ways, the Cherokee balance of labor, home, and gender began to fall apart. Even more broadly, Cherokees in the 1800s abolished the clan law, adopted a national constitution with an elected principal chief, and provided for inheritance along male as well as female lines, decisions that all furthered the empowerment of men over women. As Taya Miles and others have documented, stories of domestic violence going hand in hand with alcohol abuse and slavery abound during this time. Of course, the ultimate upheaval for the Cherokees was the Trail of Tears. In the 1830s, in which the Cherokees were marched from their homes to Indian Territory, leaving all wealth, stability, and social order of their homes and townships behind. In one of the most famous stories, which remarkably has everything to do with gender and domestic violence and violence in general, a Cherokee man named Solly got into an altercation with soldiers when they made some kind of offense to his wife while trying to remove her from their home. Solly and his sons escaped to the hills and ended up sacrificing themselves to a U.S. firing squad so that certain Cherokees could come down from the hills and remain in their traditional lands. His descendants live on in the membership of the Eastern Band of Cherokees, which I'll talk about in more detail in a minute. As for the rest of the Cherokees, they were rounded up and marched in the dead of winter from their homelands in the east to Oklahoma. The various routes for those journeys are shown here. Terry Henry, again, the Eastern Cherokee Tribal Council member, who will also come up later, has said, "Thousands died on the trail due to lack of food, clothing, shelter, and other horrific conditions endured during the march. Like other federal statutes and policies towards Indians, the Removal Act legalized the death of thousands of Cherokee children, women, and men. As Cherokee people, therefore, we experience federal law and Supreme Court rulings differently than other Americans. As Indian nations and women, we also experience an epidemic of violence differently than all other Americans." One of the particularizing aspects that Terry Henry might be referring to with respect to Indian tribes as they try to deal with violence within their borders has been the federal government's decision to strip them almost completely of criminal law enforcement authority and its ensuing unwillingness to exercise that jurisdiction itself. So just a few highlights or lowlights here. The Supreme Court held in 1978 that tribal courts no longer had jurisdiction over non-Indians on their reservations. Same year, it held that it only had misdemeanor jurisdiction, that is probably 1 to 3 years jail time, over Indians who committed crimes on reservations. Federal prosecutors, left to fill the gap, decided not to and have declined, according to a number of studies, to prosecute 50% of murder and 76% of adult sex crimes in Indian countries. Therefore, and this is putting it really politely, there are extreme jurisdictional enforcement gaps when it comes to violent crime in Indian country. Indeed, reservations can be havens for violent crime, and when Congress heard testimony from women who had experienced domestic violence, they heard remarkable similarity among women who had tried to call for help, whether to federal, tribal, or state police, only to learn that nobody would come, with their abusers learning that that was a pattern that they could rely on to keep abusing them with impunity. So this was the scenario, historically, culturally, socially, and legally, when Rashida Manju visited the Eastern Band of Cherokees in 2011 and met with the descendants of those who had experienced the worst of violence and conquest, as well as its continuing legacies. This is a community that, like many Indian communities, has faced its share of poverty, ill health, family instability, and so on, as well as high rates of domestic violence, with little redress in the law. But the tribe has, for the last 15 or so years, been turning things around. Starting in 2002, it passed a new tribal law outlawing domestic violence, providing redress to the tribal court for protective orders, as well as emergency responder services, public safety, juvenile, and offender rehabilitation programs. It also, on the social level, created support services for family to help with the social and cultural elements of healing for women, men, and children alike. Then, in a critical set of decolonizing moves, the tribal court began to limit the impact of the Oliphant decision, that one that had stripped tribes of jurisdiction over non-Indians, invoking, amazingly enough, international human rights law in its own decisions, holding, for example, that when the Supreme Court had held that tribes don't have jurisdiction over non-Indians, it had said nothing about non-Indians who weren't citizens of the United States, and so asserting jurisdiction in some cases there. But advocacy didn't stop there. Clan Star, the nonprofit formed by Cherokee women, decided to participate in briefing to the Inter-American Court on Human Rights in the relatively famous, especially here, Jesse Gonzalez case, in which an Indigenous woman had tried to call for help in a domestic violence case leading to the murder of several of her children when the police wouldn't come. Terry Henry, the Eastern Band chair, went on to advocate with many other women for national legislation, including the Tribal Law and Order Act and the Violence Against Women Act, which together sought to and ultimately did reverse a portion of the Oliphant Indian Civil Rights Act statutes and restored a small modicum of jurisdiction over crimes committed by intimate partners in Indian country. All of this was sort of coming to a head when the UN Special Rapporteur came to the Eastern Band. And in one way, her visit might have been symbolic, but it seemed to do more than that. As Henry later described, the visit gave Cherokee women a chance to expand their consciousness, to reach an international representative with their history, and to describe all the ways in which they were making a difference, whether they were answering the hotline phone, or they were working as a clerk in the tribal court, or they were just providing assurance to a friend in the community. The engagement with the Inter-American Commission and the Special Rapporteur connected the experience of Cherokee women to all women across the globe and helped instill a belief, as Henry said, that Cherokee women have the right, as citizens of the Eastern Band, to the protection of their government. The resulting report from the UN Special Rapporteur looking at the situation of Cherokee women across history has become part of the international discourse on rights of women. Okay, the second case study, and we're nicely moving along, hopefully. This has to do with the Navajo Nation, a nation that is close to our own home, with over 300,000 members and a reservation of 27,000 square miles in the Four Corners region. For years, the Navajo Nation has been a leader in developing legal institutions and substantive law with the express goal of imbuing contemporary practice with Navajo values and processes. The Navajo Nation operates a three-branch form of government with popularly elected legislators and executives, as well as an appointed judiciary. Navajo traditional or customary law, as well as the legislative code and judicial decisions, are all vibrant aspects of Navajo governance. In 2006, the Legislative Council of the Navajo Nation created an entity broadly devoted to human rights, the Navajo Nation Human Rights Council, to, quote, address discriminatory actions against citizens of the Navajo Nation. The Navajo Nation Human Rights Council receives complaints, conducts investigations, gathers information, and engages in advocacy work. It advocates for Navajo rights, especially in the areas of discrimination, sacred sites, forced relocation, and unexplained deaths, through communications with local, state, and federal governments, as well as with international human rights tribunals. What is so remarkable about the Navajo Nation Human Rights Council is that it takes a deeply integrative approach to human rights in terms of substantive law. It draws primarily from Navajo law, particularly the Dene principles of being resilient, content, disciplined, and maintaining peaceful relationships with all creation. These principles, described in more detail in the Navajo language, are prominently on the NNHRC's website in all of the work that it does. But the Commission's work also relies on international law principles, even in some cases to critique the positive law within the Navajo Nation. Regarding self-determination, for example, the NNHRC draws on Articles 3 and 4 of the Declaration, which define self-determination as an attribute of Indigenous peoplehood. It contrasts this with the Navajo Nation's own legislative code, which describes self-determination merely as a goal, and has accordingly called for the Navajo Nation to elevate the role of self-determination in its own law. In one set of claims, the Navajo Nation Human Rights Commission has addressed the United States Forest Service's decision to permit development on a sacred site in Arizona. This is one of the tribe's 4 holy mountains, a marker of the homeland, and it figures prominently in the tribe's creation story. The U.S. Forest Service, nevertheless, has decided that this is an appropriate place to have ski area snowmaking using treated sewage effluent, much to the dismay of tribal religious practitioners. Unsurprisingly, given what the Supreme Court has said about the fact that the First Amendment doesn't apply to tribal sacred sites, and in fact that the federal government has the authority to destroy sacred sites on public lands, the federal courts have upheld the Forest Service's decision in this case, and the Supreme Court denied cert. The Navajo Nation Human Rights Council decided to pick up this case and work with the Navajo Medicine Men's Association to draft a statement of information to the UN Special Rapporteur on the Rights of Indigenous Peoples when he did his country report in the United States. In that report, the Human Rights Council referenced all of the important reasons from Navajo fundamental law, why the sacred site is so important, as well as the Declaration's Articles 11 and 12, giving Indigenous peoples the rights to sacred sites and religion. But the Navajo Nation Human Rights Commission's work is not limited to claims against the United States, and I think this is one of the things that makes it so interesting. To the contrary, the NNHRC has on its website a complaints form that envisions human rights complaints against a variety of entities, including the Navajo Nation and its instrumentalities itself, considering that the NNHRC may consider the tribe both benefited and bound by principles of human rights law, and subsequent actions have borne out this description. The NNHRC's opening move was a study on race relations that called on not only local border towns, but the Navajo Nation itself to enter into cooperative memoranda of understanding to address problems including employment discrimination, homelessness, and unexplained murders in border towns. Not long after, the Navajo Nation Human Rights Council heard testimony and ultimately decided to oppose federal legislation, water rights legislation, to settle Navajo Hopi claims on the Little Colorado River. This was legislation that, from what I gather, and there are people in this room who've worked on Navajo water rights for longer than I've been alive probably, but this was legislation that was supported by John Kyle and was tentatively supported by the president of the Navajo Nation. And I have really no opinion on whether it was right, wrong, or somewhere in between, but from the perspective of some grassroots activists, the proposed legislation failed to reserve enough water for grazing, had undesirable benefits for Navajo Generating Station, and had not been fully vetted with the community. The NNHRC expressly invoked the UNDRIP's provisions on free, prior, and informed consent to say that the Navajo people in their rural subsistence lifestyles had not had enough time to digest the legislation. They had not had the opportunity to read it in their own language, and so therefore they could not have meaningfully provided consent. The resolution that the Navajo Nation Human Rights Council developed on it cited Article 26 of the UNDRIP on natural resources as belonging to Indigenous peoples, but it also told a powerful statement of the Navajo creation story and the role of clans and ceremonies in water and vice versa, suggesting, and apparently effectively so, to the tribal government that it had not sufficiently considered Navajo law in its deliberations. After a resolution by the Navajo Human Rights Council opposing the bill, the Navajo Nation Council itself voted to kill the settlement, and that was the end of it. So what can we learn from this story? This example crystallizes our understanding how even internal Navajo Nation power brokers can be and are challenged by a distinctly tribal human rights commission that is fueled by tribal cosmologies, as well as the force and persuasion of human rights law. This sits in direct contrast to some of the concerns about the isolated nomos, the insular community that is not going to be self-critical and protect the rights of Indigenous individual members. I'll conclude by just noting that the UN itself, I think, is also going through this process of decolonization. Some of us were just recently there. Carla Fredericks, who runs our Indian Law Clinic, and her students represent Vicky Corpus-Talley, who's the current UN Special Rapporteur on the Rights of Indigenous Peoples, featured here. The two main issues that we heard being discussed there were addressing the situation of Indigenous peoples' status and participation in the UN, as well as implementing the provisions of the UNDRIP, perhaps through some revision of the mechanisms that address Indigenous peoples' law there. Neither of these goals, like any of the goals we've discussed, is going to happen overnight, but as we sat there listening to states, NGOs, and Indigenous peoples talk about the common understanding of Indigenous peoples' rights, the importance of participation, of consultation, of dignity and status, it did seem that some of the discourse has permeated those walls in a way that is ultimately going to make a difference. So here we are now, the last slide. You've been very kind to bear with me. Just to wrap it up, I've argued that with the rise of international human rights, increasing Indigenous participation in legal development, and paradigm shifts in international postcolonial theory, we may now be witnessing a truly Indigenous human rights movement, one that pervades law at every level. In the paper, we argued that this is a potential realization of Cover's vision and Nomos and narrative, in which communities absorb, process, and create law all the way down. But just as importantly, in this instance, we argue Indigenous peoples are influencing law around and outside of their communities, all the way up into state and international practice. By participating in the human rights movement as peoples, Indigenous peoples have begun to transcend the state-centric model that often excludes other groups meriting attention on the world stage. And they've begun to develop and advance a broader agenda of decolonization with a vision for a nomos, a normative world in which individuals and peoples live more freely. So here's the redemptive power of jurisgenerative communities in action, creating meaning, resisting violence, and inviting new worlds. Thank you, and I welcome your comments. Carla Fredericks has kindly agreed to circulate the mic. It's 6:25, so we'll probably, I imagine, just do a few comments because there are refreshments waiting for us next door.
And it's our tradition here at Colorado Law to take the first question from a student. Oh, sorry.
Hello. Professor Carpenter, what do you see as the most effective means for implementing the UNDRIP? Agencies, legislation, or courts?
This is the discussion we had in my class today. Exactly that. Yes is the answer. So implementation domestically has to occur through all of those means, through agencies, legislation, and courts. I had an interesting conversation with Rick Collins recently where he suggested that in the United States, we look to the federal courts, right? We look to the federal courts to respect and effectuate robust rights. We need something that we can take to the federal courts to empower the norms and principles in the Declaration. But I think you can take to court things that are coming out of agencies, things that are coming out of legislation. I think, as we said in class, it's probably going to happen piecemeal, agency by agency. I'm not sure Congress is about to adopt the entire Declaration as a matter of federal law, but wouldn't that be great?
Thank you for your amazing talk. How does this moment of this jurisgenerative moment connect or differ from the American Indian movement in the 70s, 60s?
That's a fabulous question, and I love it. So, and I haven't thought about it, so I'm really talking off the cuff. But the similarities, I guess, that I see would include that the American Indian movement inspired a great awakening in consciousness among members of tribes across the country in the development of commonalities in struggle, commonalities in agenda. I think the self-determination movement grew out of the activism of American Indian movement members. I think ongoing respect for both tribal distinctiveness and the power of pan-Indian activity is a signal marker of that movement. You might say that there's been a similar trajectory of the international human rights movement in that the coalescence of an international identity among indigenous peoples, but still respect for the diversity of 370 million people across the world is important. I think in both cases we're probably still watching, right? Watching to see what the results and promise are going to be. But that's a question I'd like to think about more. It's a good one.
I always have a lot of questions, Kristen, after your talks and papers, which are always so well done and enlightening and elegant. And so it's not a hard question, I don't think, but it actually was something I was wondering about when you were describing your Navajo Nation case study. And is there a risk that in some cases, and I would love to hear your thoughts about which cases, that the promise of using the Declaration or the organs of international dispute resolution are more distracting and sucking away activism and energy than they are contributing, and that's with full recognition of the many instances including the amazing Cherokee case study you described, where they're not. They're contributing, and it's all sort of working together in this jurisgenerative way, and that's so acknowledging that there will be plenty of those, and that you document. Is there a typology of the risk side where nothing is actually going to occur, and yet then Indigenous people have sort of been distracted, been sucked up into sort of a legal possibility that will never actually bring them relief or the remedy that they seek?
Sarah historically always asks the hardest question, starting with my job talk, where she, I'm just teasing, thank you. I mean, it's a great question, and I think it's one that, again, many of us in this room have been thinking about for a long time. It is incredibly expensive, incredibly time-consuming to participate in international advocacy. And I went to Geneva for the very first time in September to the Human Rights Council's 30, whatever that was, session, and participated in some of the deliberations around Indigenous peoples' issues. And it was absolutely stunningly remarkable to me that people had come from Western Sahara, from Borneo, from communities across the world, and I couldn't imagine the expense and the effort and the energy it took to get there when it was hard enough for us to get there from Boulder with, all the resources in the world. And I was really struck by this one woman, a young woman activist from Borneo, who said she was there because her community was about to be inundated with flooding that it hadn't consented to as part of a dam project. And what could we tell her that might help with the situation? And it was one of those, rubber hits the road moments. What can you offer us to really respond to a dire situation? And we talked with her for a while about some of the different provisions, how to, think about domestic legal regimes and where you might get an in those regimes. But my sense is that the typology for Indigenous peoples is a little bit what I said earlier, that when they feel like they've exhausted options locally or domestically, that might be one of the times when it is appropriate to go to international law. The Western Shoshone, I think, have really gone up, down, left, and right in everything they can possibly do in the United States. So where else are you going to go? I guess if you look more substantively, the area where human rights seem to be having the most traction for Indigenous people's claims is in the area of land rights. And so the jurisprudence out of the Inter-American Court and Inter-American Commission would suggest that there's some real traction, and there is starting to be a history of implementation in a number of states, if not our own. So I guess on the plus side, that's an area I think there is some utility. I think some other areas where I guess I'd leave the rest of the world open to the other areas where we haven't yet seen that much movement, but I'm still hopeful, and I guess I'm hopeful given that Indigenous peoples will keep making these claims. They have to make these claims, and so I think it's the multiple site thing. But there's always going to be a challenge of distraction and resource scarcity and et cetera. So that's an imperfect answer to a difficult question, but a good one. Should we do one more question and then adjourn? Oh, Kim is always a good one for hard questions too.
Well, thanks, Kristen, for your amazing scholarship. I guess this is kind of implicit in your whole talk, but maybe you could speak specifically to the issue of, and it's a question I asked Jim and Aya, whether Indigenous rights are best protected through arguments from universality or exceptionalism.
Yeah. This is the other $70 million question. So, and the question, in case some of you in the back couldn't hear it, is whether Indigenous rights are best protected through universality or, did you say particularism? Exceptionalism. Okay, great. Yes, great question. So I think Jim would argue, and I think he has argued, that Indigenous rights are universal rights, and that it's because of the situation and history that we need to remedy violations of Indigenous people's rights, that CERD, ICCPR, and others haven't been able to fully remedy Indigenous peoples' rights because the history has evolved in a way to put Indigenous peoples in particularized circumstances that require remedies, but that are doing what all people would expect, making sure that all people have the right to religion and property and equality and their children, and et cetera. And this is also a question we've talked about in my class. I appreciate that argument very much, and I appreciate its political power, as well as the shared moral commitments of all people to ensure a baseline of equality. I also think there may be some aspects of Indigenous culture that are particularized, and I think particularly of the relationship between Indigenous peoples and their lands. Now, this may be because I do most of my own advocacy in the area of sacred sites, and there are certainly peoples around the world for whom religious sites have certain significance, and there's a lot of advocacy and coalition building that we can draw around it. But it, as you know, as much as anybody, when Indigenous peoples are talking about sites that they actually emerged from or migrated to, where their entire cosmology and belief system and kinship and political system is grounded in, I think that is a somewhat particular experience that is hard to, or has been hard as a matter of US law and I think laws of other states to really make meaningful. And that may be an area where it's worth looking more contextually at that situation. I'm sure there are others, but that's one that certainly comes to mind.
So, Kristen, I want to thank you for being willing to do this. For people who know Kristen, you won't be surprised to hear she was somewhat reluctant in agreeing to really grace us with incredibly thought-provoking, interesting ideas that I will continue to be thinking about. But more importantly, as befitting for our amicus issue worked on about engaged scholarship, this is a phenomenal advertisement for how important scholarship is for wrestling with deep, important issues in a rigorous and serious way. The way you've engaged your students is inspiring, and working with Carla in terms of in practice, it's such, to me, a heartwarming reminder about the work we do and how it makes an impact on multiple levels. So thank you very much. Let's celebrate you next door with a drink. Everyone, please join me in thanking Kristen for a great talk.